Morning everybody, hello, welcome to today's webinar presented by Amanda Chadwick, Senior Speaker at Peninsula Business Services Limited. Today's subject is all about health and safety for the small business, and what I have done is, because lots of people ask me for my notes after this webinar and presentation, is I've actually put as many notes into the presentation as possible, so when you download it off YouTube, you're not busy sat there at the moment trying to scribble down notes, but you can actually get quite a few of the notes off YouTube when you download it. So I'm Amanda Chadwick, I'm a Senior Speaker at Peninsula Business Services. Our niche is supporting the employer, managers, proprietors and directors with health and safety and employment law and HR issues, anything from sickness to absence to everyday issues like maternity and paternity. So let's get cracking. Right, health and safety. Why manage health and safety? Well, the reason you're going to manage health and safety is because you have a moral obligation to do it, a legal obligation, and economic reasons as well, because actually by having good health and safety in place, it can save you money. Imagine if you have a fire and it's your fault that the fire started because of negligence. Do you think you're going to be insured for all the products that you've lost, or maybe people that have been injured? No, you're not. So economic reasons too. Currently 1.1 million people suffering with work-related illnesses, over 111,000 reportable major injuries, and 173 fatalities. That's 173 people going into work and never coming home again. That's really sad, isn't it, in this current day and age? 27 million working days lost to the UK economy. Absenteeism is always a big massive subject with health and safety because it falls into that category, and also there's lots of crossovers between employment law and health and safety, which we'll talk about later on. Right, so who's affected and who has unlimited personal liability? Well, proprietors, owners, directors, partners, managers, trustees and governors. So we've got fines, we've got criminal records, custodial sentences, and also you could be charged with corporate manslaughter. You have health and safety responsibility for the visitors, which we'll talk about later on, employees, which we're also going to talk about, contractors, which we're going to talk about, and contractor agreements, and also volunteers as well. That's who you're responsible for. So why manage health and safety? Well, unlike an ordinary court of law, in tribunals and health and safety courtrooms, there's a reverse burden of proof. And every employer shall appoint one or more competent persons to assist him in undertaking the measures he needs to comply with the requirements and prohibitions imposed upon him by or under the relevant statutory provisions. So, excuse me, that's the reverse burden of proof. So, reverse burden of proof. Well, if you have an accident, if there's an injury, you are assumed guilty until you prove yourself innocent. So if you have no policies in place, no procedures, no assessments, don't do training, you've got no personal protective equipment, you do no monitoring, and you don't keep registers, guess what? And no records, you are actually guilty. So you have to have all those in place, and we're going to talk about that shortly. So why manage health and safety? Well, business protection for a start. Especially high importance with 5 or more staff. Now people think, oh, if I've got less than 5, I don't have to bother with it. But let me tell you, it's much easier to get things in place at the very beginning than it is to backtrack. And anyway, if somebody does have an accident, you've only got 2 staff, they'll still look for reporting procedures. So it's a requirement as well for tendering. If you're tendering for something, it's great to show that you've got good health and safety, you've got policies, procedures in place, you have insurance as well. It's creating a positive, safe working environment, and it also increases productivity. So, health and safety check. Have you got a written health and safety policy? Is it regularly updated? Are all employees trained and guided through this on induction? Do you have proof? Ongoing training on health and safety, staff and management fully aware of health and safety responsibilities. You're not just told them what they've got to do. So again, have you got that written health and safety policy, and is it given to all your staff? Who is the responsible person for health and safety, and who is your competent person? How do they know that they are? Is it in their job description? How is information, instruction, training and supervision given to staff? Who carries out your risk assessments, and when were they last reviewed? Have you a current fire risk assessment, and who carried it out? Have you appointed a responsible person for fire safety, and who monitors your fire procedures? Example of fire drills, of fire alarm tests, etc. How do you record and follow up accidents and near misses? So those are some of the very serious questions that we're going to talk about throughout this webinar. So the crossovers with health and safety and employment law. So this is your health and safety book, and this is your employee handbook. The crossovers, there's major crossovers here. They are joined at the hip now. We've got the working time directive, that's breaks, that's holidays, that's working hours. We've got maternity, somebody telling you that they're pregnant, so a maternity policy, disability, and then we have equality law, then we have absence procedures, absence monitoring, back to work interviews, because that ties in with health and safety as well, and then accident reporting, and then personal protective equipment as well. Those are all the crossovers we've got with health and safety. So whatever's written in your handbook needs to be written in the health and safety policy too. So I'm going to give you some mythbusters now. Health and safety regulations now ban the use of ladders. This story reappears regularly. You probably read about it in the Daily Mail. In fact, there is no ban on ladders so long as they are used safely. There are regulations aimed at ensuring that people do use ladders safely, but this is to reduce the number of workers seriously injured or killed falling off ladders every year. Each year, an average 13 workers die this way, and 12,000 are seriously injured. However, there is no ban on ladders so long as they are secured and used appropriately. And remember the working at height regulations and people working over 6 foot. You know, you're more likely to secure yourself if you're going above 6 foot. Below that, you don't. And yet there's loads and loads of accidents that actually happen below 6 foot. Myth 2. School children are not allowed to use cardboard egg boxes and craft lessons on health and safety grounds. Well, I know for sure. This is just standard guidance within education. It makes perfect sense, really, because we want clean toilet rolls. We want clean egg boxes. And it's really probably related to a decision by Essex County Council to issue a circular indicating that there is in fact no problem. It's just a health hazard, that's all. Myth 3. Workplaces are risk averse and employers are overly cautious because of the fear of health and safety regulations. Listen, there's no evidence that employers are being risk averse. The fact that over 1 million workers get injured every year and 25,000 people are forced to give up work because of injury or illness caused by work shows that employers are very much taking risks with their workers' health. Most of these injuries could have been avoided if employers had implemented proper safety procedures, but research has shown that around half of employers have not even done a simple risk assessment, and that is a legal requirement. So myth 4, you've heard this one, you've read this one, firemen's poles have been banned on health and safety grounds. Listen, there was one fire station that couldn't actually fit the pole in, so they didn't put it in, but the press got wind of it. So this seems to have arisen from a case in Devon where it was reported that to avoid the risk of injury when sliding down poles, a new fire station had not been equipped with a traditional pole. The truth was there was no room for it, okay? There are no regulations banning the use of poles in fire stations. So, myth 5, there are now more regulations and red tape than ever. In fact, there were more than twice as many health and safety regulations and laws 35 years ago than there are now. The legislation that remains is now generally simpler and easier to understand. So, myth 6. I hope you're enjoying these myths. These are ones you can talk about in the local pub. A local authority ordered the removal of St George's flags from outside shops on safety grounds. And this story originated in Liverpool. However, Liverpool Council did not ban St George's flags or ask anyone to remove them. It did require one shopkeeper to properly secure flags after one fell onto the windscreen of a car causing an accident. See, urban legends. People report it in the press. Small businesses are being strangled by over-inspection and over-regulation. Okay, the average small business is likely to be visited by health and safety inspector around about once every 20 years. Even larger businesses, except for high hazard ones, are visited on an average every 10 years. Small businesses are even exempted from some regulations. For instance, while every employer has to do a risk assessment on their staff, if a business has less than 5 employees, it does not even have to write the assessment down and record it. Hardly a major burden, although we do like to see a reporting procedure in place. Myth 8, trapeze artists will be forced to wear hard hats. This story has appeared several times over the past few years. Sometimes the ban is blamed on European legislation, other times on the new work at height regulations. The claim is that these regulations will require trapeze artists to wear hard hats. This is, of course, complete nonsense. The reason that hard hats are worn is to prevent people being hit from falling objects. not to protect you if you fall. They are completely inappropriate for trapeze artists, and there are no regulations or plans for any regulations to introduce them. A related story is that the work at height regulations would mean that safety signs would have to be erected on the side of Snowdon. Again, there is no truth in this, and I live in North Wales. I can tell you there isn't. Health and safety regulations have fueled a huge rise in compensation claims. Okay. The number of civil claims for compensation against employers as a result of accidents has fallen every year for the last 5 years. In fact, despite the introduction of no-win, no-fee claims, the total cost of compensation cases in Britain has remained, in real terms, static since 1989. Britain also pays out much less in civil compensation as proportion of its economy than any other major European country apart from Denmark, and a third of that of the USA. Myth 10. We're on the last myth now. A church spent $1,300 to change their light bulbs because of health and safety regulations. Read into it. The church in question was St Benet's in Norfolk. It was reported that because of new health and safety regulations, electricians now had to put up scaffolding every time they wanted to change a bulb. In actual fact, the electricians weren't just changing the light bulbs, but actually putting in whole light fittings. The contractor said that because of new regulations, they had to use scaffolding, and it was standard practice. So, let's have a look at health and safety now. Do you really need to have a health and safety policy? Of course you do. You must have a written health and safety policy if you employ 5 or more members of staff. It is a legal requirement. It's there to establish what arrangements you have in place to manage the health and safety and welfare of your employees. Without a written policy, it will be difficult to prove you have not been negligent in managing health and safety risks involved with your business, and in the case of an accident that could lead to large fines or imprisonment. As an employer, you must assess and manage health and safety risks, whether you are large or small or self-employed. Accidents and ill health can ruin lives and damage your business. You are not expected to eliminate all risk, but you are required to protect people as so far as reasonably practicable. You'll hear that phrase a lot in health and safety. Do you have an employee health and safety handbook? You know what? To ensure that your employees fully understand their responsibilities and specific safety rules applying to them, you should provide a handbook or rule book advising all your employees of the safety arrangements you have in place to protect those who may be affected by your operations. It is vital that everyone is aware of their individual responsibility, particularly where legal duty has been delegated to them. An employee health and safety handbook is an important tool ensuring everybody has this awareness. It is absolutely advisable to make sure that every employee signs to say they have read and understood it. It's your defence at the end of the day. How often should I review my documentation? You should revise your policy as often as is appropriate. It is recommended that this should be carried out at least annually, but there are many issues which may affect your safety policy, which could result in the need to review the detail more than often than annually. And it could be a change in your operations, your premises, new equipment, new legislation or guidance relevant to your business operations, like the withdrawal of a certain crane or lifting equipment or cot bedsides, etc. So risk assessments. It doesn't matter if you run a business, however large or small, you must carry out a careful examination of what activities you undertake that may pose a hazard to others. You need to examine the work you undertake, how it is carried out, and whether or not this could harm. You need to establish what, if any, controls are required to reduce the risk, and what, if anything else, you could do to reduce any potential for accident or incident. You need to do them. Okay, how often? Whenever possible. You should carry out the risk assessment before the job is started, before a piece of equipment or machinery becomes operational, or if a person who is particularly vulnerable, i.e. a young person, a new or expectant mother starts. Again, as before, review your risk assessments with business change, process, accident, technology, etc. And the new or expectant mother, that brings me back to the employment law handbook. You can only do a risk assessment if somebody tells you they're pregnant. So a term and condition that says let me know when you're pregnant. You have to at the earliest stage. I bang on about inductions, don't I, all the time in my webinars. It is a process used by employers to help new starters to integrate into a new role, familiarise themselves, get used to the company, make them aware of processes, procedures, training, rules and safety in the workplace. And they can be, it takes different lengths of time really depending on the size of your company. Employers are legally required to provide health and safety information. Inductions usually cover all the facilities, health and safety information, fire safety information, duty, structure, introduction, terms and conditions, rules and regulations, and company overview. And it's at this point that you get a copy of somebody's where you get their license, you check it with the DVLA, and you refer back to your car policy as well, and them updating you, P45, etc. So then we go to visitors and contractors. You have a duty of care to ensure so far is reasonably practicable the health, safety and welfare of their employees at work, but also visitors and contractors. I want a visitor's book, but I don't just want an exercise book that says, oh, I signed in at 9 o'clock and I came out at 10. Who's going to crop that book when there's a fire? Listen, in that visitor's book, I want delegation of responsibility and authority to a visitor. I want it to say, you know what? This is my visitor's book, and on the left-hand side, take the time out to read the terms and conditions of entering into my premises. It actually says where you can go, where you can't go, what you can do, what you can touch, what you can't touch. And it also says, we draw your attention to the fire and bomb evacuation procedures. And also, if you have an accident, you have to report it immediately today, not 3 months down the line, okay, if that makes sense. So, contractor's policy. A contractor is somebody brought in on the premises to work but is not an employee. So we're looking at a painter, a decorator, a plumber, somebody who comes in to do work for you. In a client-contractor relationship, both parties will have duties under health and safety law, and you may have a different book for contractors to sign into. The extent of the responsibilities of each party depends on circumstances and agreements. And for me, when I'm taking a contractor on, I'm going to ask what experience they have in that type of work. Employers, I want to see their employers and public liability insurances. I want to see their health and safety policies and practices. I want to know about any recent health and safety performance and the number of accidents they have, what qualifications and skills they have, and I'd have like a tick box before I take them on. The selection procedure for subcontractors, and what I would be doing is I'd be looking at the health and safety training arrangements, and what I would also do then is I would pass the paper around, turn it when I offer them the contract, and I'd get them to say they are responsible for their own health and safety. So I'm going to delegate responsibility there a bit. So, training. You know what? This is just one of the 4 elements of Section 2, Bracket 3 of the Health and Safety at Work Act 1974. The 3 remaining being information, instruction and supervision. Any employer providing these 4 elements will be fulfilling a major part of their health and safety requirements. The importance and value of training cannot be overemphasized. Employees need to be fully aware of their responsibilities relating to health and safety of not just themselves, but fellow colleagues. Training should be constant to allow for changes. All staff training should be recorded in the company safety records. Staff should be required to sign to indicate they received the training. And you know what? Legally, for me, a winning word is understood. Review all the time the health and safety training needs of employees and to ensure they are competent for the tasks they are required to perform. Fire risk assessments. We're going to talk about this later on, but there was a change on October the 1st, 2006, and the Reform Fire Safety Order 2005 came into force. It's because I'm on a roll. And as a main requirement, a responsible person must carry out a fire risk assessment to determine what general fire precautionary measures are necessary to protect relevant people. In more complex buildings, when intricate escape arrangements and large numbers of people reside, a higher operational fire risk process needs to be in place. A more comprehensive fire risk assessment may be necessary, and you may need professional assistance and guidance with that because of the amount of fire escapes, the amount of people that work there, or the higher risk of the operation that you run. Remember, it's a live document and it should be kept abreast of building changes. So you need to remember that. We've got reporting accidents. This is always top of somebody's hit list for asking me questions about. You know, all accidents must be recorded in the Data Protection Act compliant accident book. This came about, gosh, it was about a decade ago, I think now. And what had happened is this lady, I'd had an accident at work. This is many, many years ago. And the old accident, do you remember you could write your name and address, your telephone number, etc. Really? You know what? You give it all your personal information. And what came out was this lady was being stalked, and the stalker got her home address from the accident book. And when she was in court, the judge said, actually, that's not to data protection compliant, is it? The accident book isn't. Look into it. And the change happened because of that court case. So on the back of that now, the accident books look totally different. There's no personal information in there. But all accidents must be recorded in this book. This is followed by why the accident occurred and any corrective actions required to ensure there is no reoccurrence. Some accidents will also need to be reported to the Health and Safety Executive, commonly known brackets HSE, under the Reporting of Injuries, Diseases and Dangerous Occurrence Regulations. You may have heard of RIDDOR. It's RIDDOR. A simple breakdown of these are deaths, major injuries that result in over 3 days absence from work, and these regulations also list a number of diseases and dangerous occurrences that must also be reported to the HSE. Let me tell you about reporting accidents. Many people we take on as clients, we go out to help them, we rip things to pieces, we put it back together again, and the amount of accident books that we have gone through, and they've never reported their accidents, and we know there are many that they should have done. Okay, so take notice of what I'm saying. So, do you issue personal protective equipment? Okay, there's several things here. You know, if you're issuing personal protective equipment, it's costing you money. So we had an incident a few years ago where one of our clients was issuing safety work boots. Then people would come in every few months going, can I have a new pair, but never providing the old ones. And what they were actually doing was selling them on eBay with protective clothing. So you want to have some agreement in place in your employee handbook that says before, for example, you get your protective clothing, your new ones, you have to bring the old ones back for replacement. So, it's cost saving, isn't it? To ensure compliance with current health and safety legislation, PPE should only be supplied and used at work wherever there are risks to health and safety that cannot be adequately controlled in other ways. PPE that is required should be identified in the risk assessment completed for the task being undertaken. When PPE is established as the only effective means of controlling the risk of injury or ill health as a result of a comprehensive risk assessment, legislation, listen to this, states that it should be available free of charge for use at work. So no charging your staff for it if your risk assessment has said that you need it to prevent an injury or ill health. Amount of employers that say, I charge my staff for it, or do I have to, can I make them pay? No, you can't if there's a need for it. Where, for good hygiene reasons, PPE should be issued to each individual employee for their exclusive use, this should be the case. This would apply to gloves, earplugs, etc. All reasonable steps should be taken by the employer to ensure that PPE is properly used, maintained and stored in the proper manner. So it goes back to your policies and procedures again and writing things down. And then we've got hazardous substances. I'm giving you a great overview here today. Specific hazardous substances legislation requires employers to identify all those substances. There's a list there, chemicals, fumes, dust, vapors, mists. We're talking about flour as well here, and biological agents and germs that are linked to their undertaking and carry out an assessment of the health risks associated with exposure to the substance. Once the assessment has been carried out, communicate the findings and control measures that are specific to that product. The importance of employers' liability insurance. It's sad, isn't it? But I do meet companies that haven't paid for their insurance. That's illegal. Nearly all companies that employ other people are obliged by law to have employers' liability insurance. This protects their employees against the hardship caused by any injury or disease that they suffer resulting from their employment. The Employers' Liability Compulsory Insurance Act 1969 demands that an employer has insurance cover against such claims. This helps your employees, but also protects your business from the expenses related to serious accidents or illnesses. Let me also tell you, you have to keep that certificate. You have to keep it, because I meet many people that have been operating for years and years and years, decades, And if I've had an accident in 1981, I'll be claiming on the insurance that was in place in 1981. But lots of these insurance people change hands. So you've got to keep the certificate to prove who you're insured with at that time. The importance of employees, we've done that one. Sorry, I've repeated that slide. The cost of accidents in the workplace, okay? There are uninsured costs, aren't there? These are things you don't think about. Investigation time, overtime payments, production delay, sick pay, excess on any claim, legal time, loss of business contracts, reputation, damage to tools. You know, these are things that, you know, you haven't thought about, the costs that are uninsured. So, these are your top 10 own goals. These are where employers go wrong. This is where the biggest mistakes are made. And this is what I want you to check when you leave me today. Ambiguity over the identity of the competent person and their role and their job description. Directors, owners failing to supervise or follow up on the implementation of the health and safety management system. Failure to act upon earlier recommendations and notices. Failure to follow ready, available and easily accessible guidance. Employees acting outside their training, instructional skill set. So 2 young lads pick up a compressed air machine, jet spray, lark about with it. None of the supervisors are there because they're around the corner and have their fag together, and one of them loses their eye. Tolerance of unsafe working practices. Incomplete personnel files and lack of formality. So no induction, no contract documentation, no rules, etc. Inadequate training records for staff. Yeah, I think they were trained. Well, where's it written down? Well, they weren't trained if it wasn't written down. Failure to consult with employees in the preparation, implementation and revision of risk assessments. Risk assessments, neither suitable nor sufficient. They're the top 10 goals for your business. This poster, you're familiar with it. That's out of date. Well, it will be because it expires in 2014. The new poster is out now. It's user-friendly. You can purchase it already. I want you to take note. It's much more simpler for employers to know what they must do. It's also more simpler for the employee to read what they must do if there's a problem. There's a telephone number on there. It tells them how to go through the route if there is a problem. Health and safety consultation representation. That box needs to be filled in. There's a fine if it's not filled in. And also, it also refers now to employee rights. So it's actually got a section on there now to refer them back to employment rights and also fire safety regulations too. That's the difference. So, just so you know, the fire officer no longer visits, inspects or certificates unless specific law. You do need a fire risk assessment. You must have one as the employer, and it could also apply to the managing agent leasing you the premises and the landlord or owner. So bear that in mind. Measures to be adopted include undertaking a fire risk assessment, developing a procedure, providing a means of detection and alarm, and managing the fire procedure and control. Do you know what? I was at a presentation the other day from a great training company who I work with, and it's amazing how many companies sat around and never actually operated a fire extinguisher. And it's amazing, isn't it, when we think about somebody choking, how many people have actually done the movement on the chest, what's behind movement on the chest to make somebody choke, you know, to bring the object out of their throat. How many people have used a fire extinguisher? How many people have actually put out a fire? And how panicky would they be? So we need to develop a procedure. We need to train people how to use these fire extinguishers and which ones go with what. We need to write that down. And we also, you know, when we have like an evacuation procedure in place, we need to actually utilize it and test it. People have them in place. There was a care home that had fire evacuation and procedure in place, and they'd put it in place, but they'd never actually utilized it because they said to do it at 4 o'clock in the morning was not fair because the residents slept. So, you know, ensure that employees are trained. We've got the reverse burden of proof here. Again, fire safety logbook contains alarm test records, training records, enforcing authority visit records, equipment test and maintenance records. When did you actually test the sprinklers? Fire procedure checks, safety equipment checks. The responsible person must carry out a fire risk assessment. The responsible person is the employer, person in control of the premises, or the owner of the premises. So, We've had a change, haven't we? We've had the fee for intervention come in. I don't know if you've heard of this. The rationale behind this was the Health and Safety Executive introduced the fee for intervention cost recovery scheme, and it came into force on the 1st of October 2012. It's duty upon the HSC to recover the costs of its interventions under the Health and Safety Working Act 1974. Interventions arise when an inspector considers it necessary to provide written advice on a material breach or to serve a notice following a visit. From the health and safety perspective, between a quarter and a third of all inspections have resulted in an FF1I charge. Over 1,400 invoices sent out, over 700,000 in the first 2 months on bills. Now it's 2.6 million recovered, and there's an average of £500 per invoice. David Ashton, the Health and Safety Executive Director of Field Operations, said the money is really coming in. Costs are recoverable from the start of the intervention until when the breach giving rise to the advice notice has been remedied. Costs include the following. I won't go through them, you can read them for yourself, such as writing letters, taking statements, gathering the information and assessing the findings. The practical points. Charging rate is £124 per hour for the Health and Safety Executive. Businesses are to be invoiced monthly and it's payable within 30 days, a bit like a parking ticket. Queries and dispute resolution and appeals procedure does not currently extend to local authority interventions. Local authority are sort of your high street shops. You know, anything you see on the high street, really, the local authority deal with. So we're looking at, you know, environmental health. So at the moment, it doesn't currently extend to those people. Interventions resulting in a letter, it's £750. Interventions resulting in a notice is £1,500. The industry types that will be affected are the following: education, manufacturing, woodwork, furniture, motor vehicle repair, public services. Have a look at them. Removal companies, health and social care, couriers, recycling, printing, council premises. So, I've given you a minefield and I've given you such information today. I want you to protect your business and integrity of your insurance. Protecting your business. I'm going to show you a literally a minute video now, which you'll find interesting because it's got statistics on it, and then you'll hear me talk again. So don't log off and listen to this video. Hang on, if I can get it up. Hang on a second. And I want you to watch it. It's one that we've designed, and I want you to read. It's actually a very good. If I can open it, actually. No, it's not opening, so sorry about that. It's actually a brilliant video. I'll try and log on to it while you're on the line anyway. So how do we Peninsula support and protect your businesses? We have a health and safety service, and we have Business Wise. It's a 24-hour device, risk assessments, training, and instruction. You can see how we protect our clients. What I'm going to do while you're listening to me is actually I'm going to give you my email address, and I'm going to play the video for you, so bear with me a second. My name's Amanda Chadwick. You can contact me at amanda@peninsula-uk.com. So Amanda Chadwick at peninsula-uk.com. And here's the video. Hello everybody, I hope you enjoyed that video. Okay, I'm going to give you those email addresses again now for you to contact me if you have any queries. And the email address that you should contact me on actually is amanda@peninsula-uk.com. If you want some advice on health and safety or employment law and you want some free advice from me, contact me at free@peninsula-uk.com. If you want access to our video, my webinar today, or any previous webinars that I've hosted, please feel free to contact me on a YouTube, and it's PBS Press and PR. So PBS Press Office, I think it's under. So it's YouTube /PBS Press Office. That's the YouTube link. If there's any problems anyway, you've got my email address, amanda@peninsula-uk.com or free@peninsula-uk.com. I hope I've helped you today. It's been a very informative webinar today, and I know your attention span goes after 45 minutes. So it's a goodbye from me, and thank you very much for listening for me today. I hope to speak to you again soon. Thank you very much.